Well. How are we doing today? This is Raymond with Smoothoperationoflaw, and today I am going to cover why you can't get your UCC-1 recorded at the Secretary of State's office. Okay, what is a UCC-1 and how do UCC liens work? UCC-1 financing statement are commonly referred to simply UCC-1 filings. UCC-1 filings are used by lenders to announce their rights to a collateral or liens on secured loans and are usually filed by lenders with your Secretary of State office when a loan is first property or piece of equipment. When a loan is first originated. Sorry about that. UCC-1 filings can be either filed for specific assets, such as commercial property or a piece of equipment, or as a blanket lien covering all of the borrower's assets. You'll quickly find that UCC-1 filings are fairly common in the world of small business lending and are nothing to cause alarm. Okay, first off, the UCC-1 is a commercial filing. The UCC-1 does have other options of how it can be filed. UCC-1 must originate from a borrower or a creditor. When people are talking about, must originate from a lender or a creditor. When people are talking about putting a UCC-1 on behalf of being a secured party, it is possible. What is not possible is if the document that you are putting together is not really a loan to begin with. You cannot just loan all kinds of assets randomly with confusing parties. You must loan your personal assets into either another person or an entity. Think about it. It's a lending type of ordeal. It's a mechanical type of ordeal. A mechanic that does work on your vehicle can secure his work on the vehicle with a UCC-1. What you are not going to do is randomly put UCC-1 filings on random people who never borrowed a goddamn thing. Period. You can use UCC-1s as a result of acquiring an adjudicated matter, i.e. judgment. What you are not going to do is send a 3-part process to a judge and expect that judge is now somehow financially obligated to whatever piece of junk you sent through the mail. Unless if that non-signatory actually received a benefit. Here's an example. I go to a judge. I write a letter saying, hey, judge, this is a commercial lien, blah, blah, blah. And then I start to put all of these laws that the judge might have violated that are up for dispute because everybody in the United States is innocent until proven guilty. So if I send a document with a bunch of laws that judge just broke and there is no real remedy unless a trial is held, there is no real commercial property in use that we can show through traceability that the judge actually got a benefit that is financial and commercial off of an asset that is commercial or property or labor. You going to jail is not a commercial asset to the judge. It is a criminal asset of the state. And what is that asset? Your ass. Because under the 10th Amendment, they are allowed to police their territories constitutionally as they see fit, as long as it does not violate the Constitution. Not everything that you have a problem with is a violation of the Constitution, regardless of what your opinion is. All facts and matters are balanced against that document known as the Constitution. Where does the Constitution say you cannot be arrested at all? It doesn't. It doesn't. So as far as the example of, hey, let me send this judge a bunch of violations that they've committed because I feel like they're giving me a traffic ticket, or like they're arresting me, or like they're taking my assets. And because the definition in the United States is commercial under federal statutory law, which it is, that does not mean that the act that they are conducting is unconstitutional. The argument that there is a de facto government when the Constitution was ratified is not an argument. What commercial property is the judge taking? What commercial property are you lending? Well, tell me. Put it in the comment section down below. That is to open up this discussion today. That is all that is, okay? Today we're going to talk about when is it appropriate to file a UCC-1. The problem with most people is that they don't go online and they do not research the document that they are filing. If you are going to file a document with a state agency, why would you not go and read everything up on that document? When is it appropriate? When is it not? Does the Secretary of State have discretionary provisions inside of their policy to review your UCC-1 and deny it and send you a filing refund? The answer is yes, in a lot of states. Sometimes they can look at your UCC-1 and just determine that it might be ripe for the possibility of fraud. How? Well, let's think about it. If you put a UCC-1 with the same name, the same way on that document, upper and lowercase, that could be ripe for fraud. If they feel like the entity that you are going to use with a UCC-1 can be an alter ego, that you are just bullshitting. Your alter ego being that entity, meaning that that is just another you. You are just creating confusion. If in their discretion they believe that that is what's going on, they can deny you. They can deny you. Let's read further to find out more about this mystical UCC-1. What does UCC stand for? UCC stands for Uniform Commercial Code, which is a set of rules that help govern U.S. business laws and commercial transactions. Technically, the UCC isn't a set of laws itself, but more a model that individual states follow. Each state has its own implementation of the UCC rules, but the rules don't vary that much from state to state. Okay, let me break that down. What the UCC is, it is a set of code of conduct for how business should be conducted within the state so that it is of a certain standard that whether in that state or other states, they can view that the nature of the transaction is recognizable, is not fraudulent, and meets a criteria acceptable in between states. Okay, let me break that down even more. Back in the day, in the early portions of this country, different states, which are United States, in fact, our nation states, had their own currencies. The currency was not centralized. So dollars from one state and whatever the hell from other states, which were their dollars, their form of currency or their form of securities were ripe for fraud. Why? Because people were counterfeiting money, saying that it was from a foreign state, and there was no equivalent on the acceptability. Joe Blow inside of a, 1700s type of Walmart would not be able to recognize what maybe a North Carolina dollar looked like. So they started to create situations and where instruments and commercial dealings had a standard for interstate commerce. Now again, do they vary in between the states? Yes, they can vary in between the states just a little bit, but ultimately they share mostly the same principles. UCC is pretty much a code of conduct for commercial activity within the state so that it meets a certain standard recognizable between that state and interstate commerce. If you have a UCC 1-308 in New York, it might not be UCC 1-308 in Florida or Texas or Wyoming. Maybe in Florida, it might be UCC 1-307. But because it is within the Uniform Code of Conduct, it generally should reflect what UCC 1-308 in New York says so that Florida instruments can be viewed and accepted as something recognizable inside of New York State. But Raymond, what about the Constitution? How about Article 1, Section 10, where contracts and obligations between the states can't be prohibited and they should be recognized, like licenses. Okay, look at your license. Look at a license from another state. Are they exactly the same? No. Do they meet a lot of the same criteria? Look at them. Yes. And oftentimes, licenses, when they're distributed by the DMC upon the party who requested it, they meet a standard and are in a database. They're in a database. And the databases communicate as to what is valid and what is not. Because even though the DMV is your state's Department of Motor Vehicles and not the Department of Motor Vehicles of another state, and might have different requisites for how to obtain maybe a license, that does not mean that the instrument known as the license does not come with a picture, name, date of birth, and a standard all across the board that allows for recognition, even though the colors might be different, funny, or whatever. Might have a watermark, might have a barcode. Who knows? They meet on the instrument's face. a leveling criteria recognizable between the states, and they are linked through a database. Okay, so UCC-1 filings explained. If you're approved for a small business loan, a lender might file a UCC finances statement or a UCC-1 filing. This is just a legal form that allows for the lender to announce on a secured loan. This allows for the lender to seize, foreclose, or even sell the underlying collateral if you fail to repay your loan. We highly recommend you research if your lender regularly files UCC-1 filings and requires collateral before applying for a small business loan. Even if you're completely confident that you'll be able to repay the loan, we still recommend caution here, as UCC-1 filings can impact your business, as we describe in detail below. 2 types of filings. Okay? UCC liens against specific collateral. This type of lien gives creditors an interest in one or more specific identified assets rather than an interest in all the assets owned by a business. These are most often used for inventory financing or equipment financing transactions. UCC blanket liens, the lien gives a creditor a security interest in all assets of the borrowers. This lien type is commonly used for loans from banks and alternative lenders, as well as loans guaranteed by the Small Business Administration. Blanket liens are preferred by lenders because they are secured by multiple assets and are therefore less risky. In some cases, a blanket lien might carve out some assets that will be exempt from the lien. This might occur if the remaining assets are more than sufficient to reimburse the lender should difficulty occur. UCC-1 filings typically use movable assets as collateral, which can include vehicles, office equipment and fixtures, investment securities, inventory, receivables, letters of credit, and other tangible items of value. For example, if you take out a loan to buy new machinery, the lender might file a UCC-1 lien and claim that new machinery as collateral on the loan. You would, of course, work with your lender to designate what the collateral will be before you sign any documentation committing to the loan. If you sign a secured loan, all of the designated collateral is now the property of the lender until your loan is fully repaid. Your lender can seize the collateral if you fail to repay the loan. When a lender files a UCC-1 with the appropriate Secretary of State, meaning the Secretary of State for your residential state or the state where your company is incorporated or organized, the lender is said to perfect its security interest. Legally, this means the lender can enforce the lien in a state court with minimum fusses. In cases where the collateral is tied to a specific physical property rather than financial assets, the UCC-1 is filed in the county where the physical property is located. The UCC-1 becomes a public record, allowing potential creditors to see whether a given property is already pledged against an existing lien. So now what I'm saying is this. Dude, your UCC lien must be filed against an actual asset. What physical asset do the courts have of yours? You can't put a body for assets. You can't even put a body in a trust. There are laws against putting a body in a trust. I'm not going to go through all of them right now. But the UCC-1 does what? It secures a loan. Now, can you loan a trust assets? Yes, you can. And yes, you can have that trust obligated. But if you have a lien on a UCC-1 into a trust, you still own those assets. And what is the loan for? UCC1s are used for loans or are used for creditors. Creditors that have a right to your property. Now, if you have a judgment and they must pay you, can you put a UCC1 lien on an individual? Yes, you can, and all of their assets. But you better find out what are their assets. What if you don't know their assets? That's the whole reason why the court is there. That is the whole reason why the court is there. If you want to collect with a judgment, that is another discussion for another day. But I will lead into it just a little bit. You must get a writ of execution on that judgment. A lot of times people just get a judgment and do not get a writ of execution. You must also be able to find out through investigatory acts with the Secretary of State, what is that debtor's assets? What are that debtor's assets? Excuse me. Everybody wants to file a UCC1. Like, I got a UCC1. On what? Do you know what else you can have a UCC1 on that this internet website failed to mention? You can have a UCC1 on intellectual property. Yes, you can loan somebody your trademark. Nike can put licensing rights or grant licensing rights for a specific sum total, allow a smaller business or a specific type of sneaker department that makes sneakers for Nike, like Jordan, to use their symbol and share in the profits. But that is usually secured by a contract. If not, you are going to go into court one way or another, whether you develop a cease and desist with a waiver of consent clause and you tell the party that upon using your commercial asset, you now have allowed, the party has now became a non-signatory bound via receipt of a benefit of your intellectual property because they may be using your name on documents and getting a financial payment directly as a result of using that name. And then, yes, maybe then you can get a party obligated. It happened to Stormy Daniels. There is a case, President Trump versus Stormy Daniels. Okay, she received an actual commercial asset, like $150,000. She didn't shut her mouth. And then what happened? She went into court trying to say that Trump was trying to silence her and that she's brave and whatever. And next thing you know, because she never returned the $150,000, she was obligated to the contract. Amazing. Your intangible property that has an actual commercial value, if you can prove that it has a value and that you actually have rights established for your name being a trademark, you too can tell people they can become a Stormy Daniels. You can put intellectual property on a UCC1. You can put a house on a UCC1, but there must be lender to creditor. I'm telling you right now, if you have an irrevocable trust, you gave all those rights away. Why would you be the creditor to that trust? You are not loaning that trust if it's irrevocable. That contradicts the name. It is irrevocable. You cannot collapse those assets. If you had a grantor's trust, just a living trust that is not irrevocable, then you can have a lien because, in fact, you can crush the indenture. that would be valid. So the minute your shit says irrevocable, they're probably looking at your document saying, fuck you. If you're just doing the straw man being indebted to you, like they used to do back in 1992, then guess what? What you're really saying is that you are the owner of those assets and everything that's associated with those Social Security card, even though you're trying to say that the Social Security card is indebted to you. Because what it looks like is the same shit where you started from, which is that if that Social Security straw man is supposed to be used for you at all costs throughout commerce and everything about it is owed to you, that includes its use and the debt. Another party is not the receiver of that loan on that UCC-1, so they are not the debtor party. You cannot get the state in trouble for contract interference. They must be an obligated party to the contract. Let me give you an example. If I have a UCC-1 versus me and the straw man, that doesn't mean that the judge is obligated to any of the terms and conditions in that security agreement. What the fuck is that? Are you crazy to think that the judge is going to not be immune from that fucking contract in which they never received anything from that transaction? You are out of your mind. The judge is completely immune. It's the same thing as if I have a contract with Sally and I tried to hold Sandra liable for it. That is not how contract interference works when it comes to state claims. That is not how contract interference works when it comes to state claims. States will have judicial immunity. The state must be obligated. So you must directly have a contract with them of the commercial asset. The problem is people are trying to use the law and thinking that that's their commercial asset. That is not. That is what courts are for. What you need to do is have a commercial asset. Have a commercial fucking asset. And your name becoming a trademark makes it a commercial asset. That's why, pursuant to Title 15, United States Code, Section 1122, no government officials, law firms, or anybody is safe. And you have congressional consent because that's why it was made law. Stop it with the UCC-1s. Just stop it. You don't even know what you're doing if you're putting that out there without doing it appropriately. I just did you the biggest favor by waking your ass up and telling you, you're using the UCC-1 wrong. You're using it wrong. And what's anybody going to say to me? I just read it. You can do a cursory search on Google and find out for yourself. I just gave you a case that it would work if you gave them a commercial asset, such as money or intellectual property rights. It's intangible. It's sticky tape. But it's something of value as long as you can prove that your business is in business. All right, guys. That was an awesome freaking class. Hey, check this out. I'm this week alone. Anybody that hits me up, okay, on Messenger, check the link in the description. You got my Facebook. You'll have my Messenger. If you want to be a part of my course, 6 months, half price right now. Call up immediately. It'll be that way for the rest of this week. And today is, I believe, February 2nd. Yep, February 2nd. So from now till about Friday. So that's February 5th. Half price. Half price. 6 months, 1 hour a day. Half price. Call now. First 20 will receive the discount. First 20 will receive the discount. So that means act now, act fast, call me and learn how to do this stuff right. Do not go around just filing random paperwork and not being able to actually back it up. In the course, you will learn how to create a proper UCC-1 lien and actually be able to foreclose on it. And if you have a problem with foreclosing on it, depending on your state, whether it's judicial or non-judicial, because that needs to be included, then I will help you, and meaning in the course, you will learn how to foreclose on a on a loan regarding your state. How to go to court and actually do it. All I do is show people where it exists on the internet. This is not legal advice. Not necessarily. If this is legal advice, which it ain't, then why is it all over the internet? We are just having a freedom of speech conversation, okay? You're donating for speaking fees, just to hear my mouth go. All right, so that's all I got, and I hope you guys have a God blessed day and do whatever you guys got to do. Make sure you call me. It's good stuff.